me bring in Mr. Dendo Kpemka, really, considering that we have existing laws, but crime still exists, and you've heard Sam George go through the Criminal Offences Act, we have the Marriage Act, the Child Rights Act, amongst others. The Constitution also, at least, makes provision for all these crimes or the concerns that this particular act or bill seeks to remedy. The concern then is this particular bill consistent with the Constitution or the laws of this country, and is it that we are just basing it on the principles of cultural values and emotions?
Thank you, Emefa. Thanks to your cherished viewers. Thanks to your good self and my brother, with whom I'm well pleased. He's a very good brother of mine. And I've always thanked him. I have always told him that myself and my wife are grateful. When I had my wedding, he had to travel all the way from Accra to Bolga to attend. So
he's a good brother.
He's a very good brother. I've listened to the advocacy for and against this bill as it is now being passed and awaiting presidential assent. But you see, there are some novel situations that I find in this particular bill that I commend it. And I'll come back to that. But you see, for example, if you look at the section 17 that he read, I have presided over and led my side of the House in discussions when I was Deputy Attorney General to pass several bills into law with the kind permission and support of my boss at the time. We passed several bills, so some of them so controversial that for many years they gathered dust, they were never passed. We passed them into law between the period 2017 and 2020. We did not have things like these protective sections that we have under Section 17. So those who have the fears that people are going to be harassed, intimidated, beaten up, and etc., I think Section 17 is enough a cover-up for that. But you see, again, we don't exist as a nation in isolation. We exist among the Committee of Nations. And as a nation, we have some principles of jurisprudence that we espouse, the dualist principle and the monist principle. The dualist principle basically is talking about the fact that you have your domestic laws and then you have international law that you have also domesticated. You know, you've signed up to international treaties and organizations, and so you become a part of the Committee of Nations. And so those laws have been domesticated by your parliament. And so you have an inclusion of the local and foreign law, which is the dualist state, and the strict monist state that rely only on law of the soil or your country without due regard to the international committee. Now, in our case, we have a mix of the two. A mix of the two because there are some of the international treaties and organizations and international commitments that we have made as a people that we have domesticated by legislation and etc. So those ones are separate and distinct from those that we have not committed ourselves internationally. So that's the beginning of this discussion that I want to look at. Again, if you look at what Parliament just did, I think that it is in line with a jurisprudence principle by one Jeremy Bentham, which is the utilitarian principle, that you take decisions that will bring happiness and joy to the greater majority of the people. And Parliament, the reflection that they had, the conversation they had, the discussion they had, the analysis and everything, point to the fact that what they have done will bring greater joy to the greater majority of Ghanaians. Now, it is not without regard to minority opinion anyway, because minority rights are also supposed to be protected. And that is why I again commend them to the skies about what they did specifically under Section 17 to protect, because otherwise we're going to have tomorrow morning people chasing and beating up others at market centers and other places, by the roadside and etc. That fear that the majority of people had has been settled by the provisions under Section 17. Now, there's a particular question that has been raised time and again, and people have made very definite pronouncements, and I find those pronouncements too conclusive and unfortunate. You see, the only court in Ghana that has the right to declare the constitutionality or otherwise of a law passed by the Parliament of the country is the Supreme Court. So until the Supreme Court makes a definite pronouncement, whatever you say, those your beliefs, those things that you think are unconstitutional and etc., until it is definitely pronounced upon by the Supreme Court and give credence to what you are speculating, what you are saying remain in the realm of conjecture and personal opinion. And sometimes you may think that what you are saying is so simple an issue that when it gets to the Supreme Court, they will uphold your position. And the Supreme Court, by the purposive interpretation, which now is applicable in every case that they do, can interpret and apply the law in manners that will conform to societal norms. And so those who are concluding that the law in its current state and form is unconstitutional may get it wrong, because until the pronouncement is definitely made by the Supreme Court, we cannot come to that definite conclusion. Because the Supreme Court, when the matter is brought before it, there will be two sides of the coin. The arguments will be espoused, and the constitutional principles that each of them is seeking to actually say that have been infringed upon will be espoused. And it's for the Supreme Court to make a determination. Okay. And then from what the Venerable Sam Georges espoused this morning, when you look at that, I mean, he dealt with it decisively. But go back a little bit and look at Article 11, our sources of law as a country. You know, if you look at the sources of law, it includes customs or customary law as they are defined in each of the localities or societies of. And
this addresses Mr. Whittle's concern.
Absolutely. So customary law is a part and parcel of us. So if we seek to legislate customary law, it is lawful to the extent that it does not infringe or impinge on any particular constitutional dictate or principle, clause, or whatever. So if you read Article 11 and you read 39 under the directive principles of state policy, as Sam George did, then you would come to the conclusion that, look, what we need to do really is to ensure that in enacting these laws that protect our values, we do not infringe a particular provision of the Constitution. And again, he got it right when he stated that you read the Constitution as a whole if you want to actually have a discussion that is holistic and come to certain conclusions that will be acceptable. You need to read the Constitution as a whole. Otherwise, what you do is that you may even go and read a clause of the Constitution, and your understanding of that clause alone is what you espouse. But when you read it and then read subsequent clauses and clauses that preceded that, it will give you a holistic understanding, and you'll be able to get the whole constitutional architecture and the reason behind it to be able to espouse it. Now, I'll soon zero in on this particular principle. As he indicated, in the directive principles of state policy, our Supreme Court has actually distinguished in a number of cases that we have certain portions of the directive principles of state policy that are justiciable, and other portions are also not justiciable. And they've been able to distinguish. If you read the CIBA case, the Council of Indigenous Business Association case, and the National Lotteries Authority case, and etc., the Supreme Court made pronouncements on the directive principles of state policy that on certain occasions they can be justiciable, and on other occasions they may not be justiciable, because the directive principles of state policy serve as a guide and an aspiration as a people that this is where we aspire to be at. You know, there are lofty ideals, you know, because if, for example, you look at it, the economic aspirations, etc., you realize that there has to be, economy has to be managed in such a way as to bring greater joy to the majority of the people and to reflect our customs. So clearly, if you look at the directive principles of state policy against the backdrop of Article 11 and 39, you realize that we need to, as a people, legislate as and when we need to be able to address increasing societal dynamics. And mind you, 30 years ago, the discussion we're having now may not have a reason at all.
Yeah.
You know, so it's as a result of evolution of time that certain things come up, that we begin to realize that a lacuna has been created, as a result of which we need to legislate to fill in that lacuna as time grows. If we fail to do that, then people can exploit that lacuna and create society in a manner that there will be chaos, which we will not want to actually happen. So laws are actually, if you read the memorandum to the bill, laws are made to fill in certain lacuna created as a result of time. So if you read the memorandum, it will come out very clearly that these practices that we are talking about, LGBTQ plus. I mean, they've even added so many of them,
Last
you know,
year.
and I could see
That's where the plus
that,
comes
I mean, there were circumstances of people marrying trees and all that, stones and etc., that we cannot allow to happen in our society because it is contrary to our norms and values.
Okay.
That is what basically this law is seeking to say. That, so if we go to the Supreme Court for a pronouncement, then the Supreme Court will have to look at the law as a whole and find out whether it's a fetter to freedom. Because remember that our Constitution has been couched in a manner that it principally protects the fundamental freedoms of our people without any doubt. And so anything that will be a fetter to that freedom will be looked at. But again, remember this, which does not appear to be coming from the majority of those who are also making the argument. MFA, laws, human rights are not absolute. They are enjoyed within a certain context. There are caveats to every right that you have to enjoy. If you say that you have a freedom of movement, and you go into the market square and start swinging your arms around because you have a freedom of movement, as soon as your hand touches another person, your freedom is curtailed at that particular moment.
Okay.
So no freedom is absolute, or no right is absolute. So they are enjoyed within the context of societal norms, you know, which we have to actually necessarily try to see how we can marry that within the context of our societal development. But let me state this. People are talking about the fact that unnatural carnal knowledge is an offense. That is true. But again, when we were doing the Office of the Special Prosecutors Act, I recall that we had to go through the law and take certain portions of already existing legislation and consolidate them into the Office of Special Prosecutors Act. So we went into the Criminal Offences Act and took some. We went into the Procurement Act and took others. We went into quite a number of laws, and then we consolidated them.
Okay.
I also find in this bill that they try to go into certain aspects of the law that we already have in existence, and then they put them together in one legislation to actually guide us. That's what I find. So if we declare that the entire bill is unconstitutional, then it means those provisions that are already existing are also unconstitutional, you know, and it will have far-reaching implications. Okay. You see, I know that we will come to look at implications for international community and etc.
And that's what I was coming to, whether the president should assent to this or not. We've heard Godfrey Dame, at least before the bill was passed, make a general, pronouncement about the fact that he would not counsel the president to assent to a bill that infringes on the human rights of people.
I'm soon getting there. You see, so you look at the Constitution, when you are interpreting it, you look at the spirit and then you look at the letter. If you get the letter alone and you leave the spirit out, you get it wrong. Okay. So you have to look at the two. In other words, what is the essence of this particular legislation? And as I indicated to you, would we have enacted this legislation if we had moved time back 30 years ago? We would not have. So it is because of the evolution of time and the increasing need for us to enact laws to address challenges of our times that has brought about this particular law. And look, mind you, I think Sheikh Aremiao, my elder brother, when he was espousing his ideas and etc., he made very important points. You see, if we don't take care, under the guise of rights, we may get to a state where human beings will not even exist at all to enjoy those rights, if we don't take care. Because assuming without admitting that all of us without legislation buy into this idea of LGBTQ and we all get into the practice, and then myself and George become friends and marry, and then you get another female and marry, and another person gets. I'm just giving you a hypothetical situation. Then in the end, men have married men, women have married men. We curtail procreation. And at a point in time, there would no longer be humanity, because when all of us are dead and gone, nobody can produce because the combinations will not give rise to anything. And that is why in the bill, it is very clear that they have actually talked about the natural way of procreating.
So you would advise your sexual orientation to assent to it? Maybe we should get to that.
The sexual orientation of any person is at birth. And that is what this law is seeking to actually espouse. That the sexual orientation of every person is what you are giving birth to. So I was born as a male and I remain Kpemka. So if I decide to go through some artificial means of changing my gender and etc., it will be infringing on this law.
Okay.
It's a very complex mix. If you have stated that my brother Godfrey Dami has come out to say that he will not advise the president to assent
before the bill was passed.
Before it was passed. After it was passed, I don't know whether you've heard.
You have heard from him. He says he's yet to see it.
Yes.
And to advise.
So
the president has not received
the point that we have to make that is very clear is that it's a 275 member house, and I didn't hear any dissenting voice, at least when the question was put. So the assumption fundamentally is that all 275 MPs accepted that it becomes law. And that means that it represents the aspirations of our people, because the 275
Will the president assent to it, you'd say?
That I would not be able to make a definite
Would you advise he assents to it?
Because I'm not in a position to advise the president now, because I'm not his attorney general.
If you were.
It is his attorney general.
You are in the position
I will say that for now, the circumstances of our times, I will say that for now, he needs to assent to it.
Okay.
Due to the circumstances of the time.
Okay.